All right, let's call the meeting to order. Are we live online right now? Well, good morning, everybody. Welcome to our out-of-town meeting of the Pennsylvania State Ethics Commission. Let me first take attendance. Commissioner Reddycliffe? Here. Commissioner Parcells?
Here.
Commissioner Caruso?
Here.
Commissioner McKee-Vassallo? Here. And I am present. So we, all of the sitting commissioners are here. Let me make an announcement on our executive sessions pursuant to the requirements of the Sunshine Act. The holding of an executive session must be announced at the public meeting either immediately prior to the executive session or at the next meeting thereafter. There was an executive teleconference meeting held on August 19, 2025 to review a motion for reconsideration. And an executive session will be held today, September 18, 2025, immediately following this public session to review matters that are by statute confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of applications for 90-day extensions of investigation filed by the investigative division, and administrative matters.
Hello.
This is also one of the meetings designated for public comment, although we welcome public comment at any meeting. So pursuant to the Public Official and Employees Ethics Act, Act 170 of 1978, as amended by Act 9 of 1989, and as amended by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons or organizations who represent any individuals subject to the provisions of this act and from other interested parties. We have placed on the agenda for today's public meeting a notice that the commission will be meeting today, in part to receive the input or testimony of said individuals pursuant to the provisions of the act. As our previously published notice has indicated, the commission requests copies of any statement that is presented. The individuals presenting statements before the commission will be allocated 15 minutes in order to complete their statements. The statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper, which I would not expect it to be. So with those preliminary remarks, the first item on our agenda is a review and adoption of the meeting minutes from July 23rd, 2025. Has everybody had a chance to review them? And if so, can I have a motion to adopt them?
So moved.
And is there a second?
Second.
Any comments, questions, corrections? Hearing none, all in favor of adopting those minutes, say aye. Aye. Any opposed? Hearing none, that motion carries. We have civil penalty consent. Commissioner Parcells, the Dixon matter.
There is one.
He needs to speak into the microphone for the people on.
Thank you.
Thank you. Sorry about that. You did tell me that.
There is one civil penalty case with a proposed consent agreement for our consideration. The case involves respondent Shelley Dixon, an early learning program certification representative with the Department of Human Services, who failed to timely file statement of financial interest for calendar year 2023. The parties have submitted a consent agreement proposing that the commission find that the respondent failed to file a statement of financial interest for the year stated and impose the civil penalty I will detail in my motion. Based on my review of the facts, I am of the opinion that this consent agreement is a proper disposition for this case. It is my opinion that the commission should impose the civil penalty agreed to by the parties in the consent agreement. There is nothing of record that would constitute a defense or excuse for noncompliance in this case. Based on my analysis and comments, I would like to make the following motion. I move that this commission approve the consent agreement submitted by the parties imposing a $150 civil penalty against respondent Shelley Dixon for failing to timely file a statement of financial interest for calendar year 2023. I further move, to the extent that the respondent has not already done so, respondent shall be ordered to file a complete and accurate statement of financial interest for the year stated, and she shall be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement by no later than 3 months of the issuance of the commission's order.
We have a motion. Do we have a second? Okay, we have a second. Any discussion on that motion? Seeing none, all in favor, say aye. Aye. Any opposed? That motion carries. Thank you. Commissioner Reddycliffe, I know you have a number of penalty defaults.
Thank you, Mr. Chairman. 4 civil penalty default cases are now before this commission. The respondents involved in these cases will be identified individually in the motion I will be making regarding these cases. These respondents failed to file statements of financial interest for the calendar years that I will detail later in my motion. The respondents did not take action or otherwise respond to the civil penalty proceedings. Following review, it is my opinion that as to each respondent, the commission should levy a maximum civil penalty for each delinquent statement of financial interest. It is my opinion that the commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance with the requirements of the Act. Mr. Chairman, I move that this commission levy a maximum civil penalty in the total amount of $250 against each of the following respondents for failing to file a statement of financial interest for either calendar year 2022 or 2023. Number 1, Michael Ciappelloni for 2023, Megan Thompson, calendar year 2023. Number 3, Amber Lutz for calendar year 2022, and finally, Thomas Keys for calendar year 2022. I move that these respondents shall be ordered to file complete and accurate statements of financial interest for the year stated within 30 days of issuance of the commission's order.
Do we have a second to that? Any discussion about that motion? Hearing none, all in favor, say aye. Aye. Any opposed? Motion carries. Thank you. Commissioner Caruso. If I can. Thank you.
There is one default administrative penalty case for the commission's consideration. Respondent Scholastic Inc. is a registered principal that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting threshold for the first quarter of 2025. A warning notice was issued to the respondent, but the respondent failed to comply within the 30-day cure period provided. Based upon the record before us, it is my view that the respondent's transgression of the lobbying disclosure law was negligent. At this time, I just have want to make note that there was no filing made as of July 22nd, 2025. I would inquire the investigative division if you've heard anything or there been anything else contact with this respondent. Okay. And one other question that I would just ask, this is just a kind of a favor to me. In the averments, I would request that when we do these types of things, if the investigative division could enumerate the attempt to serve the individual, like, you know, the certification, when it was sent, when it was received, and if it was signed for, that just make it a little clearer for someone like me looking at these.
Sure, and we can certainly do that. I do want to tell you, it is our ordinary practice that we serve these documents by certified mail, and we do get the signed green card back before proceeding. So that is our ordinary practice in these administrative penalty
Okay.
cases.
Thank you, Mary.
But we'll enumerate it more clearly.
If I may just update you, Commissioner Caruso, they have not yet filed either their first quarter or their second quarter expense report.
Thank you. Based on this information and the totality of the circumstances in this case, including the lack of mitigating factors, I move that this commission levy upon the respondent, Scholastic Inc., one maximum administrative penalty each in the total amount of $25,700 for their failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the first quarter of 2025. Finally, I move that the respondent be ordered to pay the aforesaid administrative penalty by no later than the 30th day after the mailing of the commission's order. That's my motion.
Thank you. Any further discussion? Yes, please.
You just heard from Ms. Lehman. This is very clunky. So hopefully you can hear us. We just heard from Ms. Lehman that they have not yet filed their second quarter. So will we be seeing this entity before us at the next hearing? And I mean, at a certain point when we're doing these types of orders, like what is the end goal? That we see this person every quarter?
We are in the process of going through the second quarter, the principals who have failed to file for the second quarter of 2025. So the end goal is to find out honestly what's going on and why these aren't. We have made attempts to contact this specific principal with the contact information that they've been required to file with Department of State.
I understand. And I think maybe next time it makes sense to limit if the motion before us is just, and this is not a criticism in any way, the motion before us is just first quarter of 2025. That should probably be the only factual predicate before the commission, before we make our order, because we are presupposing that that there will be an issue later on that may not occur. So I just think we should be very careful that this order is limited to failure to comply with the first quarter. Correct, Mr. Chair?
That was the motion, and that's what the order says. The other note I'll make, on the draft of the order in the papers, there was also a discussion that the investigative division sent an email to the email registered for the company. Let me just confirm that that's correct.
That is correct.
I mean, this is a large company that, if I also read, did I understand that they had just registered as a lobbyist in early 2025?
Yes.
So there certainly doesn't seem to be any excuse or the situation where the contact information is not right. I think our goal, as I see it, is one, we're imposing the statutory scheme that requires registration, that the legislature has significant potential fines. The Supreme Court in Penn Film Group told us we should consider mitigating factors. But if a company like this registers, gets registered mail, gets email, and does nothing, hopefully a fine of $25,000 will get them to come into compliance. That is our goal. I think we all share the goal of not being punitive or trying to collect fines. Our goal is to bring them in compliance with an important transparency law with the Lobbying and Registration Act. Any other comments or questions? Thank you. I have a motion and a second. All in favor, say aye. Aye. Any opposed? The motion carries. Thank you. Commissioner McKee-Vassallo, a gaming determination that looks similar but different than what we've had before.
Thank you, Vice Chair. The requester, Joshua Buzanko, requests a determination from this commission pursuant to section 1512, subsection 8.5, subsection 1 of the Pennsylvania Racehorse Development and Gaming Act, which I will refer to as the Gaming Act moving forward. Here are the facts that underlie his request. Mr. Buzanko is employed part-time as a server and bartender with Presque Isle Downs and Casino, which is situated in Summit Township. Mr. Buzanko is also an elected auditor for Waterford Township. Both townships are located in Erie County, Pennsylvania. The Pennsylvania Gaming Control Board, or the board, recently contacted Mr. Buzanko, noting a concern that due to his status as an elected official, he may be considered a public official as defined by section 1512B of the Gaming Act, and therefore would be subject to the restrictions of section 1512 subsection 8.1 of the Gaming Act. At the request of the board, Mr. Buzanko seeks a determination from this commission as to whether his service as an auditor for Waterford Township would bring him within the definition of the term public official as set forth in the Gaming Act. I would ask that the commission take administrative notice of the following. Under the Gaming Act, licensed casinos must pay a local share assessment levied against revenue generated by gaming, which the Commonwealth collects and distributes to counties and municipalities to mitigate the impact of gaming and related activities. The Pennsylvania Department of Community and Economic Development, also known as DCED, issues an annual report identifying all distributions of local share assessments to counties and municipalities. A review of these annual reports issued by DCED for 2010 through 2024 shows that Waterford Township did not receive a distribution of local share assessments in any amount in any of those years. Mr. Chair, I would suggest that this would be the appropriate time for any interested parties to speak on the matter.
Do we have any interested parties on this matter? Nothing, let's proceed.
Yes, so I have reviewed the submitted and administratively noted facts and the relevant statutory provisions, and I have concluded that Mr. Buzanko's service as an auditor for Waterford Township does not fall within any of the statutory provisions for the term public official under the Gaming Act. The only two provisions that could arguably apply would require that Waterford Township receive a direct distribution of revenue under the Gaming Act, or that Waterford Township's Board of Auditors have the authority to regulate or influence the development of regulations or policy relating to a gaming licensee or other matters under the Gaming Act, neither of which is present here. So I would make the following motion. Based upon the submitted and administratively noted facts, as an auditor for Waterford Township, Erie County, Pennsylvania, Mr. Buzanko is not a public official as section 1512B of the Gaming Act defines the term, and therefore he is not subject to the restrictions of section 1512, subsection 8.1 of the Gaming Act.
Any discussion?
If I may just add, I would commend the gaming board for bringing these issues to light, for flagging these for individuals who may be coming into the crosshairs of the Gaming Act. I think it is really admirable that the board is doing the job they're supposed to do and directing them back to us to give this advice. I would also say, in reviewing the submission from this individual, there is a tension between what appears to be a public official and what is a public official under the Act. And so while this individual stressed that he has no role in determining how the casino for whom he works spends money or has any influence there, that's not the determining factor, as we saw during our last meeting. So I think that it's really admirable that the gaming board is sending people back to us, and I would encourage them to continue to do that.
And just as a matter of clarification, and I'll ask this to our chief counsel, although not a public official for purposes of the Gaming Act, as the auditor, this person is required to file statements of financial interest and is otherwise subject to the public official, public employee sections of the Ethics Act. Am I correct?
You are correct.
Okay. I know we're not asked to decide that now. Sometimes that's confusing, but I'd like to make it clear that the Gaming Act is very specific in its definition of public official. And I agree with Commissioner McKean Vasallo. We have had now, this I believe is the second or maybe more times where the Gaming Board has sought clarification to make sure that people with gaming licenses are otherwise appropriately not in conflict with their public duties. So with that being said, all in favor of the motion?
Aye.
Aye. Any opposed? Motion carries. So we're going to turn to administrative matters.
Thank you, Chair Schwartz. As I laid out in the meeting materials, this is the last regular meeting of the year. And so it's time for us to schedule our regular meetings for the calendar year 2026. We have laid out one recommended location for our out-of-town meeting for next year. We recommend it be held in the Philadelphia area. We have not been to the Philadelphia area since 2018, so it's been quite a while that meeting was in Villanova. So our recommendation would be to hold it in Philadelphia or in the surrounding areas. We've also identified 4 sort of blocks of dates that we think would work well for staff. And we've circulated that to the commissioners to see if that would work with your schedules. I also want to point out that as we know, 2 of those meetings have to be our public meetings, although the public is always welcome to attend our public meetings. 2 of them are designated as for public comment. And so we need to decide which of those will be designated in that way. The first block that we're recommending would be for our first meeting of the year. We recommend that be held in Harrisburg in January, and we've identified January 14th, 15th, 21st, or 22nd as dates that may work.
I have a conflict on the 15th, so that I would just ask that not be one. Does anyone else know whether or not they have conflicts? Okay, we'll get back to you if there's another conflict, but we can have you pick from any of those other 3, assuming no conflicts. And am I also correct, just for the public's benefit, are we expecting that at the January meeting, we will likely be considering our regulations?
Yes.
Okay, so we may also want to designate that. You were looking at the second one. I mean, just for people's knowledge in advance, if we're going to have that as our regulation one, it may be worth having that as the designated public comment hearing.
That's a great idea. I agree. I think we can do that.
Okay.
Meeting number 2, we're also recommending be held in Harrisburg. And this will not be, I guess we should make this not be one of our required public hearing meetings. We are recommending April 8th, 9th, 22nd, or 23rd.
Does anyone know of any conflicts?
I have some. I can only do April.
Okay.
And I have a trial the week of April 6th, which may or may not stick, but so I'm out for the.
Okay. Should we circulate different dates for that second?
That would be
All right, we'll
helpful
circulate
if-
them.
And maybe if we could just work, there's also sometimes Jewish holidays in April. So if we could just see what the dates are. With only 5 commissioners, we'd like to see if we can accommodate everybody.
Absolutely. We'll circulate some different dates. Meeting number 3, again, we'd like to hold this in Harrisburg. We are proposing July 15th, 16th, 23rd, or 29th.
Anyone know of any conflicts at this point?
All right.
Being retired.
You can choose any of those.
Thank you.
four.
Thank you. We'll select one. And I do want to note, all of these dates we will put on the calendar as tentative in case anything comes up, we can adjust. And then meeting number 4, we are proposing that be our out-of-town meeting in the Philadelphia area, be our second of the 2 required public hearing date or meeting, and be held on any of the following dates, September 24th or October 8th, 15th, or 22nd.
Any conflicts people know of? Okay.
Can I make a comment?
Yes.
That, just from a scheduling perspective, as the division that puts together most of the agenda, if we end up holding the July meeting in like the 23rd or the 29th of July, then we would ask that it not be the fourth meeting not be September 23rd or 24th. There's just not enough time to get things accomplished the way that we want to have them done before they would come to the commission. So that we would just ask that if we move it down to one of the October dates.
Makes sense. I hear no conflict, so I leave it to you to pick and also, organize the forum. I would suggest that we look at some of the local schools or law schools as a potential center for it. Temple Law School may be a good place for it, but we can look at other places in the Philadelphia area.
Sounds great. Thank you. The next item on the agenda is a request for the general pay increase in one-step service increment for staff. I would like to hold off on making that request as we don't have a budget yet for the 2025-26 fiscal year. I'm hoping to revisit this at the next meeting that we have, but I'd like to hold off on that for now.
Great.
And then we have an operational report just to give some highlights of what we've been doing at the commission. We have laid out our remaining budget for 2024-25. At this point, it appears that we have remaining surplus of about $400,000. I note that the majority of that, $250,000, has been designated towards the new SFI filing system, which we have been working with the vendor to move that along. We've made a ton of progress on that. It's been really great. But we're anticipating having still some remaining funds, and we're using those right now towards operational expenses due to us not having a budget. We have the continuing appropriation fund with a balance of $176,935. So from a financial perspective, we remain in good shape despite not having the budget passed. Moving on to external training, as you know, we continue to do a lot of in-person and virtual trainings. We've trained over 2,000 people this year. We've conducted 26 so far and have at least 12 scheduled for the rest of this year, although it seems like just every other day we're getting additional requests. So we accommodate those as much as we possibly can. We are also working towards becoming an accredited CLE provider. I think that if we're able to offer CLE credit, we're drawing solicitors and attorneys, and they're so key in preventing issues. So we are working towards getting that accreditation through the CLE board. We continue to offer training to our staff. All our special investigators are attending the annual conference for the Association of Certified Fraud Examiners on October 21st, 2025. We have some other ad hoc trainings that we offer to staff. I never like to say no if it's directly related and we can afford it and we can swing it. I don't ever like to say no. We try and offer those trainings to our staff whenever possible. And then depending on the status of the fiscal year 25-26 budget, staff and commissioners who would like to attend may attend the COGL conference in December of 2025. We're holding off on any registrations at this point, though. In 2025 so far, our legal division has issued 38 advisory opinions. We have opened 39, the investigative division has opened 39 cases, 39 investigations. We continue to refer our cases to the Office of Attorney General for enforcement. We have had some success. There has been a bit of a hold on it. There's been some issues with IT hack at the Attorney General's office, so we were on hold with that. But they've been an amazing partner, and I imagine that they'll get rolling on additional enforcement activities here shortly. Like I had mentioned, we continue to work towards our new online SFI filing system. I'm very excited. It's going to be very easy to use from a desktop, a laptop, a tablet, and a phone. And we're designing it in such a way that it asks for the information and then populates it into the correct location on the form. So I'm really excited about the ease of use for this. We're almost to the point where we're ready to do testing internally. We're going to have staff go in and try and find bugs in it, so it's rolled out as smoothly as possible. Our plan, we are on time to roll this out as a pilot starting in January for the 2025 calendar year. If any of you are interested in being a part of the pilot and giving us your feedback, please let me know. But I'm very excited about this. This is going to make filing easier for everyone that files SFIs. It will remember the information from the prior calendar year. So it should make everything easier for filers.
Having been a paper filer, I will volunteer for the
Thank
pilot
you.
program.
Thank you very much. Yeah. And then the last item, as I had previously reported, we are moving across the hall, not very far, but we have secured a much larger space for our team. It'll help us work together much more effectively. Our plan is to be fully working in the new office space by October 6th. So it'll take some of us, I think, that have been at the commission a long time to get used to going left instead of right, but we'll make it work. And I'm looking forward to the benefit for our team. Okay, yes.
Yeah, pretty general enforcement.
Mhm.
How much have we collected?
I don't have that number in front of me. I will tell you, most of the collections have been for statements of financial interest. So most of them have been small. They've been the $250, $500, $750. I'm not aware that we've got collected anything on the larger cases yet.
Exciting to see that process.
Mhm.
She came to us with maybe last year at this time.
Yes.
It's working forward.
They have so many more resources than we do to figure out whether people have the ability to pay. So I think it takes time, but I am excited to see where we can go with it.
Mary, if I may, going back to the CLE external training,
Mhm.
you indicated that you've been approved to offer 3 courses.
Yes.
Thus far.
Yes.
What are those 3 and what are the 2 that you're seeking approval?
So they're all Ethics Act training.
Okay.
And actually 2 of them are identical. They're the hour-and-a-half standard training that we offer. The other one is a 1-hour training, also on Ethics Act. It just doesn't cover quite as much material as the longer versions, but it's the same course.
Okay.
We just need to be approved 5 times and do the training 5 times. The other 2, we're still working on details. Julie and I had a conversation just this week about doing a standalone one in Harrisburg. We're going to reach out to Department of Agriculture, see if we can maybe use some of their training spaces around the farm show area, and then advertise that through Pennsylvania Bar Association, the Dauphin County Bar Association. We don't need to limit it to solicitors and lawyers though. So we had offered this in Erie because we hadn't been to Erie for quite a while. And we sent out targeted invitations to every borough, township, municipal authority, county in Erie County. And we had a really good turnout for that training. So we'd like to do the same down here in Central PA.
Well, to me, it just seems that the solicitors would be a great starting point to remind, especially new borough council people and township folks that they need to do this each and every year. And if we can't get through those associations to remind their members, hopefully getting to the solicitors, I think is probably a great avenue to remind these people, because again, and I brought this up in the past, it's just amazing how when we go down through our one list of we've taken care of this, this, and this, but we still have to have them come back and file because they had a delinquent filing. And it's all the time.
Absolutely. Yeah. Yeah. In our standard training, it covers who we are, what we do. Because you'd be surprised at how many people don't know we exist. And then it hits on the most frequently violated sections of the Ethics Act. We talk about how to request an advisory opinion, and then we end it with a reminder about statements of financial interest filing. And depending on the length of the presentation, I did one that was 3 hours once. That was a long ethics training. I think the sweet spot is between an hour and an hour and a half. We can't get into the weeds on everything, but if people can go about their day-to-day work and recognize and just kind of get that bad feeling this might be a problem and know what to do in order to get the answer that they need, or maybe to stop doing what they're doing so it doesn't become a problem. I think that's the best. I think that's the best value we can offer through these. Yeah. And just to note, we have really great partnerships with School Boards Association, PSATs, Pennsylvania Municipal Authorities Association, the School Boards Association. In fact, Jen and I just taught well over 100 school board solicitors on ethics. So that was a wonderful opportunity. And we recently just made some great connection with the new executive director for the County Commissioners Association. So they just yesterday invited us to do a lengthy presentation at their conference in the spring. So we haven't taught for them in a very long time. So I'm excited that we've made that connection. Yes, they have, and we have a few working towards it. Any other questions? All right.
All right, so let's turn to our regulations that we talked a little bit about before. I had asked our chief counsel to gather where we had potential questions and issues. And she did a great job putting that together in a memo. My suggestion is, why don't you take us through one by one? And let's pause after each one and see if there's consensus in a direction. And if there's not consensus, I would propose that we take a vote to give direction so that we then in January have a full set of regulations. By voting on a particular direction of a provision, we're not yet voting on the package of regulations, but I think that's probably the best way to move forward. If we have a consensus, then we know what direction we're going.
Agreed.
Okay.
Actually, you just did my entire opening
Oh.
statement to you guys.
I'm sorry to take that from you, but please go ahead.
But the one thing that I would just want to make sure that everyone is aware is that once we discuss these topics today, then that should be it in terms of the initial exposure draft input, and that would allow me to put together a final package. And then in hopefully at the January meeting, barring something catastrophic, I hope to have the annex, which is the text of the regulation, as well as the preamble and the regulatory analysis form and any other documentation necessary to push the reg to the next step, which would be approval from you to move forward into the proposed regulatory status at that time. So I think
One just interruption. I apologize. Just because it is a public comment and we have some people here that may be interested, why don't we also, when you present, before we discuss it, see if there's any public input on that provision. We'll hold public comments on other issues to later, but as part of our effort to solicit any input on the direction we're going, if I can have the prerogative of opening the floor for that.
Okay. The memo that I provided to the commissioners was also provided to the group of interested stakeholders that were sent the invitation to either participate in person or via Teams. So I do see a couple of people with us on Teams, and I assume that most of them or most of those individuals are here for this portion. So we will go through, as you suggested, the different topics that we have that were still a little bit unclear and that we were going to get some additional input on. The first one is section 11.1, the definitions section, and that was the criteria to determine whether an individual is a public employee or not. And we had a suggestion from an individual to include some additional language that would expand the definition of public employee, including those individuals that have some responsibility over another individual's economic benefits, hiring, firing, promotions, et cetera. And the other potential add was the second section that would add or controls the flow of information relevant to such decisions. And I know that Executive Director Fox had some concerns about that language. And I will ask her to speak, and then I'll open up the floor to any other individuals that would like to make a comment.
Thank you. Yes. We, on behalf of the investigative division and the administrative division, we have concerns that this is overbroad, that the language, these additions would pull in individuals who wouldn't necessarily be the people who we think should be considered subject to this law. We just think that this language is overbroad. We recommend it not be included, and we stick with the original language.
Now, like I said, I see a number of people on Teams. Is there anyone that is on the Teams invite? Is there anyone that would like to make a comment on this particular change or potential change?
Folks able to come off of mute if
Hi, this is Leanne Davis. I don't know if I'm.
I think someone is trying to speak, but we're not hearing the audio. If I can ask you just to hold a second. Are you hearing it? I heard.
Hello.
You try to speak up, whoever is speaking, identify yourself. We're just having, since we're not in our Harrisburg facility, we're just trying to adjust our audio here.
Sure. This is Leanne Davis. I'm also trying to join on the video for Teams right now. Can you hear me?
We can hear you, but it's very low. Is there anything we can do to get that a little bit louder?
Could you add me on Teams?
Just give
I'm
us
in the
1
waiting room.
second. We're trying to see if we can get the volume turned up a little bit. Won't play tech, but there is a remote control over there.
Hi, is this better? Can you hear me better now?
Do you think that remote control may turn up volume there? Yeah. Oh, that could be. Want to try? No. We were wondering if we joined from here, we would be able to hear. We don't have a Teams link.
Yeah.
Oh, I'm on now. Hello. Can you see me? Teams, hello.
We see someone trying to talk, but we're not yet hearing you.
Okay, can you hear me now?
It's on our end. It's very low. We know someone's trying to speak. I think it's Leanne Davis.
Yes.
Just give us 1 second, and I apologize. Yep.
Leanne, could you try saying something now? See if we can hear you.
Okay, hello.
Oh, yes, we can hear you now.
Now we can hear you. Please go ahead.
Yes. Okay, so I just wanted to note within the definition of public employee, prior to those 5 criteria, At the top of the definition, it says any individual employed by the Commonwealth or political subdivision who is responsible for taking or recommending official action of a non-ministerial nature with regard to all these different things. And number 5 is the where the resulting official action could have an economic impact of greater than an insignificant amount on the interests of any person, including, candidates for hire. It's a wide range, right? Any person. It's not just limited to those internal to a government body. So the fact that it is intended to be inclusive of those who can recommend action which could create an economic impact. It's the suggested language was to mirror that actuality. And then I do have like a use case that I could explain as well. So I think there's like 2 different elements. One is this sort of mid-level manager who is a supervisor who reviews performance and makes a recommendation to their supervisor, but doesn't have the authority to hire or fire. Maybe you've had a job at one point where you are relying on a low-level manager to put you on the schedule. And so that has a direct impact on not only your hours of work, your pay, your promotional opportunities. So that those lower-level managers do have a huge impact on the economic impacts of our employees. So that's one example. A second example is our civil code enforcement investigators. So here at the City of Pittsburgh, we have a Commission on Human Relations that works with civil rights, and they interview folks and control who's going to be, how they conduct their investigation, who's going to be interviewed, and what information is included in their report. Their report goes to a director, and then the director takes it to a commission, much like yourself, who makes the ultimate decision. So the State Ethics Commission has found that these folks, these civil code enforcement investigators, should be included as public employees because they can control the flow of that information that would have a resulting economic impact. So those are just the, real day-to-day examples of, wherever you guys are going to draw the line, it should just be consistent, and that's all. So if you're looking for only the people who have the authority to hire and fire, you're going to be excluding a wide swath of managerial positions, and yet still requiring a lot of low-level positions to file. So that's just my 2 cents.
So thank you for that comment. I guess my question is, in hearing your description of a civil code enforcement investigator, it seems to me like that position probably already is considered a public employee under our existing regulations. Am I correct?
I believe so. Yes.
And maybe we can have the proposed addition was additional language describing a supervisor, and then additional language describing not only making recommendations, but controlling the flow of information. And as I understand it, both you, Mary Fox, our executive director, and the Office of General Counsel was concerned that that is going to have an impact of bringing low-level ministerial people into the Ethics Act that are not currently and that you don't believe exercise enough discretion that they should be. Am I correct?
Exactly. I'm concerned this is going to grab too many people that are at a lower level. An additional use case, for example, at the state, so my leave is entered by one of the employees at the State Ethics Commission. If he doesn't do it quickly enough, it gets bounced to somebody in the HR office. The way that this is written and this change to the regulation could potentially pull in that individual just by virtue of my leave getting bounced to her because there was inaction on behalf of another staff member. And that's what I'm concerned about. I'm concerned about the impacts that maybe we haven't thought through in it making these types of changes to the definitions.
Thank you. Is there any other public comment on this particular definition? Hearing none, how about among the commissioners? Does anyone have a view of whether or not we should accept our executive director's concern and strike the proposed additional language? Yes.
I agree with Mary. I think it's going to be overly. I think it will be overly broad. I agree with Mary based on my experiences that we don't want to try to get in capture all this lower level employees. And for that reason, I think we should strike it.
Just a question again, and obviously this is more hypothetical. We need to know more facts, but I don't read our existing regulations as excluding all mid-level managers. If that mid-level manager is recommending action relating to contracting, procurement, grants, subsidies, planning, zoning, inspections, licensing, all of those things, that person could still be a public employee. But maybe a manager of an administrative function that doesn't do any of those may not be a public employee unless they were the highest level in that office.
Could I
Yes.
speak to that? Or
Yes, please go ahead, Ms. Davis.
yes. To me, and speaking with Robin Hitty over the years, one of the things that I've taken away is this gut analysis of, would this be an issue to the public interest and the perception of the integrity of government if the person that's being the subject of the action is the person's brother? So I'm a mid-level manager. Can I give my brother more hours than somebody else? I'm a mid-level manager. Can I review my performance, the performance of my brother? To me, that it is concerning that this person would not be considered someone who's creating an economic impact, or might be seen as someone who should be open to conflicts of interest. So that's, I think that could be a conflict of interest, right? So if they're excluded from public employee status, they're not subject to that restriction.
I guess my concern, Ms. Davis, is I'm not sure, and obviously we need to know more facts, but a mid-level manager who offers a significant amount of hours to their family member may be engaging in activities of official action greater than a de minimis impact, and therefore would be a public employee and would be in violation of the conflict of interest rules under certain circumstances. We have to do a case-by-case analysis. I guess our question right now is in potential revisions to the definitions. We want to be cognizant to make sure that public employees that make those kind of decisions are subject to the conflict of interest rules and potentially disclosure rules. But are we incorporating too many people with the proposed additional language? And I see Commissioner McKeevis out. Oh.
So if I think that, are we talking about C and E together, or are we talking about just C and just E? Because I think that the additions to C modify supervisor, right? Is this person a supervisor who has the responsibility over tangible economic benefits such as hiring, firing, promotions, leaves of absence, hours of work? In my mind, that doesn't pull in the typist, the clerk who is approving a leave by virtue of an action. I think if we pair that with not adding the language to E that says, or controls the flow of information relevant to such decisions, we thread the needle of providing some clarity of what a public official is without bringing in people who solely by virtue of the fact that somebody didn't act timely or are truly low-level employees who, and I don't mean that in a derogative fashion at all, but individuals who are not intended to be subject to the act. So I don't think that we should be talking about these edits as in all or nothing together. I think you can thread that needle by getting rid of the language in E that we've proposed while still maintaining the language in C.
Some,
You have reaction?
not so much reaction, but just generally a comment. I understand the difficulty in trying to figure out whether an employee is subject to these definitions. I feel for Leanne because I feel like there's a lot of staff members out in Pittsburgh. Of course, it's a very large city. Trying to sort through whether someone's covered based upon their position description is a tricky task. I think it's difficult. I just don't want to lose sight of the fact that it's difficult for us to wrap our brains around every structural relationship in every single governmental entity across Pennsylvania. And I don't want to fix one small problem and create a problem somewhere else because we haven't thought about it and thought about the impact. But Commissioner McKeevis, I agree with you. I think that we want to cover the people who can have this financial impact on somebody else, no matter where they are within the supervisory structure. I just want to be careful that we're not causing more problems by trying to fix something else.
Any other comments? So I guess, when I look at this, and I think Commissioner McKeevis raises a good point, but I also really defer to our executive director who have seen a lot of these circumstances. We're not restricting it. Our current regs don't restrict that unless you're the supervisor at the highest level, that you're a public employee. If you're any kind of employee, supervisory or not, and engage in any of the activities that the current regs and the statute have, you're a covered person. So I guess the problem is someone could have a named supervisor in some part of the state or townships or county governments, but they may not really be doing things that impact financial contracts or others, or recommendations or others. Maybe it is, again, without saying anything negative about positions, it may be the typist supervisor of some group that is looking to ensure quality control rather than economic impact and hours. And are we doing too much with the changes?
Is not a supervisor with responsibility over tangible economic benefits such as hiring, firing, promotions, leaves of absences, and hours of work. If they do have the authority to affect those types of decisions, they should fall within the definition of a public employee. And so I think I worry sometimes when you look at regs that you're like reading things in a vacuum, and all of this modifies supervisor. And I agree, supervisor in the title is not what governs the distinction. It's the actual work that this person's doing. And if I have a team of people, but it's not me who's actually ensuring that they have hours or that they can take a leave, and really my job is just to make sure that the work product is good, then you don't fall within in the definition as written here. I'm just worried that I think the real issue is the controls of flow of information. Like I do have a problem with that language. I would remove that language because that considers, and I've been reading off of the vice chair's laptop, but that implies that like a secretary could fall within it because like I'm telling Mary, can you please approve this leave? I've technically controlled the flow of information. I have a problem with that language, but I don't have as much of a concern with giving an understanding of what a supervisor is, because I think that is fair.
Let's see, is there a consensus on deleting the proposed addition or controls the flow of information relevant to such actions in section E? Do we have a consensus that that should be deleted? I see a consensus that should be deleted. Why don't we just see who is in favor of the additional language proposed in C?
I actually have a proposal that might resolve
Yes.
both
Okay.
issues. So I'm sorry,
No.
Commissioner Parcells. If we made a tweak to this language in C that clarified that the tangible economic benefits for their subordinate employees, I think that might resolve some of my heartburn over this language. So it would read, the individual is a supervisor with responsibility over tangible economic benefits of their subordinate employees, such as hiring, firing, promotions, leaves of absence, and hours of work. We're keeping it within the chain rather than what I'm worried about is the, you know, who's this impacting in other agencies or other locations?
I think that makes a lot of sense. Any comments from the public on that issue before we?
That's good. Well said, Mary. Thank you.
You're welcome.
Okay, I'll take that as an endorsement. Any others? Who would be in favor of the revision as revised by our executive director? Show of hands. Okay, I think we have consensus. All right, let's go to the next one, Bridget.
Okay. The next one is more of a FYI for you. There was a concern by the Office of General Counsel at the last meeting about the definition of public official, specifically the criteria for determining whether advisory board, the exception, would be applicable. They questioned the language, enter into contracts. Mary and I met with representatives from the Governor's Office of General Counsel, and we discussed their concerns, and we were in agreement that members of an advisory board that enter into an MOU generally would fall within the advisory board exception as it pertains to the issue of MOUs, because such agreements are generally not considered contracts. So I just wanted to update you on that one. Moving on to section 15.2H. There was a question about whether we should add a definition for third-party services provider. The commission asked Executive Director Fox to research some examples of such a definition. I will let her give her explanation of the language that she proposed.
Thank you. There have recently been changes to the third-class city code, the first-class township code, and the borough code, and there's pending legislation to make the similar change to the second-class township code that would allow for an organization to serve as the manager for their local governmental entities. And what I wanted to capture was something similar to what we already do for engineering firms and law firms that serve as engineer or solicitor. And so I had tried to write language into the engineering and law firm paragraph, and it became too cumbersome. So I'm proposing a separate paragraph entirely that mirrors the language of those legislative changes to require, so if a state law permits the organization to serve as the administrator or manager, the officer or employee directly providing services to the political subdivision is responsible for filing the statements of financial interest. That's my proposal.
Any comments on that proposal? Any comments from the commission on that proposal? Do we have consensus to add that proposal? We do. Okay, thank you. Let's go to the next section.
Moving on to section 21.5, I should have said sections 21.5 H and N. There was a lot of discussion at the last commission meeting about depositions and the ability of the investigative division to do either depositions during the investigative stage or during, in the possibility that, say, a witness for a hearing would be unavailable or is unable to come to the hearing, that they would be able to do depositions. We have in the current regs that we supersede, the regs that we currently have supersede the rules of the General Rules of Administrative Practice and Procedure, known as GRAP, when it comes to taking depositions. So the suggestion was made by the Office of General Counsel to delete that superseding language. So that would allow for the taking of depositions. And I think we were all clear, and I put in some of the comments that everybody had concerning the ability to take depositions during the investigatory phase. I think that the solution of taking out the superseding of GRAP is probably the best way to handle this, unless there is something that I'm missing from the investigative division.
No, we agree with what was proposed here.
And is there any public comment on that provision? And just so I'm clear, this would allow the investigative division to take a deposition during the investigative phase and allow the parties in appropriate circumstances to take a deposition in lieu of a witness testimony. Is that my understanding correct?
Correct.
Comments from the commissioners? Do we have consensus that that should be amended as proposed? Yes. Okay. Next.
My favorite topic. Section 21.21B. Should the commission have the ability to delegate to the legal division the ability to serve as a presiding officer at a hearing in the event that a commissioner is able to attend but does not feel comfortable serving as a presiding officer? For example, I think Vice Chair Redcliffe sat through a hearing with former Commissioner Rhonda Hill Wilson that was very contentious, and from both sides there were a lot of objections and things like that. I'm not sure that the vice chair would have felt comfortable handling that type of hearing. And so I have been proposing this for a while. I have absolutely no desire to do your hearings, but I think that we need to have an option available in the event that this happens.
Any public comment on that? Any view from the administrative or investigative division on that?
We're supportive of this proposal for administrative efficiency only. And I want to note, I don't believe the suggested changes would require this to happen. This is just an escape valve if it was needed.
And view from the commissioners?
Right. And to be clear, that was my first hearing. So if I were
Fine.
right, I'd be fine now doing something along that line with you sitting beside me, helping me along with the process. But indeed, being that that was my first hearing ever, and it was an interesting one, and I'm not sure I would have been comfortable doing that by myself. So I think in that kind of a situation, we need this language.
And I probably have been the one who is most reluctant. I do think it is an obligation of us as commissioners to be there at a contested hearing and report back to our fellow commissioners credibility and other issues. That being said, as a safety valve or as an assistant, I do have full confidence in our chief counsel and believe that in the appropriate case, and especially when we are down to barely over a quorum, this does make sense. So
That's my concern.
I'm supportive of it after a lot of thought. Is there any?
That a commissioner would not be present.
No.
Correct, right? So a commissioner would still be present and I think that aligns with, I agree. I think one of our duties is to serve as hearing officers and report back, but handling of objections, I think, would be overwhelming if it is your first hearing and the parties are really going at it. So I support it from that perspective.
Yeah.
Okay.
Okay, so I do think we have consensus on that point.
Okay. I actually think that this issue may have resolved the section 21.28A when we're talking about treble damages. And it's my understanding from speaking with Executive Director Fox that they are in agreement in terms of when treble damages can be imposed and the criteria that I have suggested be added to the regs, which was in accordance of with an old resolution issued by the commission. Is that?
That's correct. We're understanding of the practical issues with regard to this, and we're no longer pursuing our objections to this.
Very good. Any comments from the public on treble damages? And do we have consensus then among the commissioners? We do. Okay.
The last issue is one that was not discussed at the last meeting. It concerns section 21.1E. And I'm going to turn it over to Executive Director Fox because this was an issue that she has raised. And I believe that this is an accurate representation and concern that she has. And I would be in agreement with her suggested change as well. So I will let her take the mic.
Thank you. As you know, one of my duties is reviewing, along with Ms. Lehman, we review all complaints that come in and we compare them to the regulatory provision and the regulatory elements in 21.1 before deciding whether we're going to flag a complaint to open. So one thing that we noticed in reviewing complaints, especially complaints that allege a violation of 1103B and C, which allow for an attempt, this regulatory provision conflicts with those. So this says there has to be an alleged violation of the act having a greater than de minimis economic impact. We feel that there is a conflict with regard to an attempted violation. So we think that in order to resolve that, we would need to add in a change to subparagraph 4. So the complaint must concern an alleged violation of section 1103A. So it bounces it to the conflict of interest provision of the act having a greater than de minimis economic impact. And that would make it consistent with the regulatory section, the definition of conflict of interest. I think it'll also eliminate potential arguments that we may have opened investigations inappropriately. And I do note, I believe that we still maintain prosecutorial discretion in deciding which complaints to open.
Makes sense. Any public comment on this new issue that was raised by Executive Director Fox? Seeing no public comment, any comment by the commissioners? Everybody supportive of adding that in? Yes, we are.
Okay, so that takes care of all of the issues that I was aware of that needed additional discussion in order for me to be able to draft the proposed regulation for your review at the January meeting. So thank you for allowing this conversation to take place and for all of the people that were listening through Teams and have provided me with direction and comments. I appreciate all of them. And I will make sure to include everyone again when the proposed package is ready to go. I will, of course, provide it to everybody, including the interested stakeholders. And hopefully we will get that going at the beginning of the year.
Wonderful. Well, thank you for all your hard work. I think you told us in the beginning that we would never get to this place. We're not there yet, but we do appreciate how much you've done, and we need to modernize these regulations, and everybody's input has been really helpful. So thank you. All right, I think we're at the time for public comment. I'm looking out, let's start with in the audience here. Do we have anyone that wants to make public comment? You may come up, sir.
In the interest of problems here.
And can you just introduce yourself so we know who you are? You could, whatever you're comfortable with.
Hello, everybody. My name is Derek Anthony Kursop, and I'm a certified candidate for magisterial judge. And my issue pertains to PA 65, subsection 1104B, which is an ethics violation, apparently. Now, you may be familiar with this form here. It's called a Certificate of Incumbent Nomination Form. 520 MDJs in this state are given this form, okay? On the form, they get to tick a box, Democrat, Republican, or both. That means they automatically get to cross-file onto both Democrat and Republican ballots without having to knock on doors. I'm a little nervous, it'll calm down in a minute. They don't have to knock on doors, okay? But it says here, by getting that unfair advantage over their opponent, getting on both ballots, they swear not to sue their opponent or violate their ethics. Except guess what they're doing? They're suing their opponents in a blatant violation of the form, and no one's stopping them. Now, I got sued 7 days after my opponent filed this form. Okay, but here's the problem. They're suing over the Statement of Financial Interest form. Now, this form here is touted as the ethics document of the century. It's just a bare bones disclaimer. You don't have to verify anything on it. But they're saying that if you don't file the form in 2 locations, you're off the ballot. This form gets stapled to the Board of Elections on your candidate package every election, right? It's on the public record. Anyone can just press print. But if you don't file this in some ancillary little department somewhere, you're off the ballot. Here's the problem. So you have an incumbent suing you illegally. The Court of Common Pleas judges know they're suing you illegally. They're not stopping it. And here's why. If you look at the filing instructions, upper court judges, state reps are told exactly where to file their Statement of Financial Interest form. State ethics, you guys, and a specific street address. We're the unified judicial system of Pennsylvania. We're one happy judicial family, except MDJs are kicked out of that house 2 floors down in the basement where the lights turned out because we're not told where to file the form. We're given the county in which the magisterial district is located, which means Lehigh County in my case. Well, I went to the county. Tim Benio, the guy who runs the Board of Elections, I said, hey, I'm the only opposing candidate. 7 incumbents got this form. I didn't. I'm the only guy who knocked on doors. What do I do to stay on the ballot? I need help. Where am I going? He goes, I'll take care of this for you. Where do I file my 4 selfies? I brought duplicates in case you need them. You just need to file 1 selfie. Well, it says I need to file 2. No, we just need 1. So I said, I'll tell you what. Can you take 2? Put them in my folder. Make sure, because I need to make sure it says 2 here. Sure. Can I get copies, please? They time and date stamped them. Wouldn't give me a copy of the second selfie. They gave me 1. They said, you can make your own copies. 4 days later, I got sued by my opponent. My second selfie was stolen out of my folder. Now I'm getting sued for not filing a selfie form in a completely undisclosed location because the incumbents are being told to file in human resources, and you'll see the lawsuit is on there. We're being told the county And the guys who run the Board of Elections are not disclosing it. I had a conversation with one of the attorneys for the county. I said, could you please disclose to me anywhere in writing that the words human resources are disclosed? Oh, they're not disclosed anywhere. Why not? Because if we had to disclose to you, we'd have to disclose to all of these people. I said, no. All the upper court judges are being told I'm the only candidate out of 8 running as an MDJ, the only one it's not disclosed to. They're all putting it on their lawsuits. So I'll cut the story short. If 1104B is being manipulated by incumbents who are legally suing their opponents, or they can get their friend to sue, that's the other deal, right? They get a backdoor ticket. Then I think state ethics should modify this and say, you know what? As long as it's on the public record, anyone can download the form. You should make one location the master filing location for a Sophie form, like state ethics, and then anyone or Board of Elections, and anyone can just press print. Because what's happening is you're hundreds of lawsuits every year, incumbents or their friends suing their opponents, wasting the court's time, wasting money. Over what? Because the incumbents want to game the system and kick their opponents off the ballot? It's ridiculous. So thank you. I'm Derek Anthony Curzon. Thanks for listening to me. Appreciate it.
Thank you. We appreciate your comments and yeah. And we'll ask our executive director just to look into this issue and report back to us.
Sure. I'm happy to do that. Can you leave your contact information for us, please? Thank you.
Any other public comment? I know we had received an email from a Dennis Smittle. Is Mr. Smittle, if I'm pronouncing that correct, here?
Yes, I am. Can you hear me?
Yes, we can hear you, Mr. Smittle.
Okay, very good. Hey, thank you, my fellow Commonwealth citizens, for this opportunity, this important opportunity for speaking. But first things first, I was hoping to be with you in person, even though it would have been a 4-hour drive from around my Pittsburgh area. But I also woke up yesterday and the first news story that I heard was about a former military man driving a small car into the Pittsburgh FBI office. Also, 3 police officers were killed in York. So I needed to switch my traveling time to at-home time so that I could prepare my presentation and have access to my computer and all that. I'd like to begin my time with a moment of silence for these 3 police officers that were killed and 2 that were seriously injured. Okay, thank you again, my fellow Commonwealth citizens and Director Mary Fox. It's just that these things are happening far too often and are existentially interconnected to the state of mental health in our country. So we have to do more, and we need to be more ethically conscious and committed. Let me introduce myself for this important speaking opportunity. My name is Dennis Smittle, and I am a lifelong 75-year resident of the Commonwealth of Pennsylvania. 35 of these years, I was employed by the Commonwealth from 1975 to 2010. After graduating from California State College in California, PA, I started working at Western State School and Hospital in Canonsburg, PA, as a child care specialist with emotionally disturbed children. This children's center was started by a young psychiatrist named Dr. Ellen Axelson, and he initiated a therapeutic milieu process for developing individual treatment or goal plans for all the children residents. I worked, learned, and played at this position and facility designed by Dr. Axelson for about 3 years. During my last year of experience at this great facility, our entire program moved to the Mayview State Hospital outside of Bridgeville, PA. And at this largest state hospital in Pennsylvania, Dr. Axelson was able to incorporate more beneficial health, environment, learning, play, and safety designs into the therapeutic milieu programs. At Mayview State Hospital, I accepted a recreation therapist position with the larger population of adult patients, all of which were in need of inpatient mental health services. Again, this was a great experience since this large facility still provided a comprehensive treatment process and individual goal plans with the therapeutic milieu team approach involving psychiatrists, medical doctors, social workers, psychologists, nurses, therapists, and psychiatric aides, with everyone's input being encouraged and respected. I stayed at Mayview State Hospital for about 12 rewarding years with more experience in the fields of health, environments, learning, play, and safety. Then around 1990, I accepted another PA Commonwealth position as a child care licensing representative with the Department of Human Services. From 1990 to 2010, I was still employed by the PA Commonwealth, and during these 2 decades, I learned the meaning and importance of compliance with guidelines, regulations, accreditations, standards, and practices, the best practices. In fact, I wrote my own guide entitled GRASP for Playground Safety, since I became a certified playground safety inspector on my own to help protect families, children, and communities in Pennsylvania. GRASP is an acronym for guidelines, regulations, accreditations, standards, and practices, the best practices. Other resources that I followed were Caring for Our Children, the National Health and Safety Performance Standards, and guidelines for child care programs. Then later on, I followed the national guidelines for Natural Learning Initiative, developed by the National Learning Initiative and the National Wildlife Federation. Upon retiring from the Commonwealth of PA in 2010, with 35 years of experience and employment, I realized I could not stop trying to help protect the children, families, and communities in PA. Some things I learned and experiences I had following my PA Commonwealth employment were as follows. One of the first things I did was to try and grant writing. I got permission from my school district and wrote grant requests for 7 elementary schools. I was successful and got $10,000 from Lowe's Toolbox for Education. I presented my recommendations and designs for a natural playground to 2 principals and a support department facility manager. Immediately after my presentation, the facility manager opened the catalog and I asked him, "What are you doing?" He responded, "I'm ordering swings." For those of you who don't know, and according to a certified playground safety inspection, swings need the largest recommended use zone and most protective surfacing for the fewest number of users. Later on, the swings were installed by a playground company from Valencia, PA, and the last school district that employed this facility manager. Also, it's important to know that grants under $10,000 do not require a bidding process for approval. Also, it's important to know that later on, the support department director was founded for ethics violations by a thorough investigation by the PA Ethics Commission. Despite the excellent investigation of the PA Ethics Commission, the school district did not take any disciplinary actions against the support department director. The PA Ethics Commission required the support department director to pay back over $9,000 for outside work done during school district hours and to do no retaliation. The school superintendent claimed no harm was done to the district, but both resigned or retired a few years later. The rest of the school district administration remains, and some were promoted. For the past 4 years, I continue to do citizen speaks at the school board meetings, submit right to know law requests, and I recently filed a PA ethics complaint. but I need to include more specific information. And none of my engaging expert and ethical efforts were more than partially granted by the PA Office of Open Records. I even participated in a Ralph Nader Law Day a few years ago. Mr. Ralph Nader and Shane Inspector of the PA Inner Circle of Lawyers answered my question regarding the convoluted process of submitting right-to-know law requests, and they both commended me for my efforts. Mr. Nader stated the burden of transparency and compliance lies with the agencies and the vendors. This was a great honor from America's greatest citizen. In closing, I believe the PA Ethics Commission is doing great work and may be the best resources for everything that is right, just, fair, equitable, and ethical in our Commonwealth of Pennsylvania. So that's my presentation, and I want to say that in the past year, I became aware of the PA Ethics Commission by watching an ethics training led by Mary Fox, and it was the most eloquent and engaging training I ever witnessed in my 35 years as a PA Commonwealth employee. So thanks again for this opportunity.
Well, thank you, Mr. Smittle. We certainly appreciate your comments and appreciate your service to the Commonwealth. Are there any other public comments?
Sir, my name is Amy Oster. I'd like to comment if possible.
Yes, I'm sorry. I heard Amy. I did not hear your last name.
My last name is Ostra, A-U-S as in Sam, T-R-A.
Yes, please go ahead.
Okay, I apologize. I know that I had spoken to Julie with ethics and I told her that I would be sending in my statement, but I have yet to do so. I just wanted to thank everyone for allowing me the opportunity to speak. I too wanted to be there in person, but I had a financial or a family situation this morning that I couldn't make it on time. Anyway, I reside in East Union Township, which is in Schuylkill County. I have been a Commonwealth employee for over 20 years. I work for an agency that's considered the agency for whistleblowing complaints. Basically, my concerns are coming from my township and the handling of my local township. As a Commonwealth employee and being responsible for ensuring that other Commonwealth employees are doing their job to the best of their ability ethically, I just am requesting some sort of oversight into local government. I am having this personal situation with East Union Township that has just turned into a total and complete nightmare. I have reached out to my local senator, Senator Argel, who usually is very helpful and very informative. I have tried to reach out to my county district attorney. I have attempted 2 complaints with the Attorney General's office. I have also reached out to ethics. My situation is, to keep it as brief as possible, my local township, it doesn't seem to want to follow the rules of the Sunshine Act, which I understand isn't the purview of ethics, but that is one of my requests. I would like, if at all possible, to see some sort of enforcement body to ensure that the local municipalities are adhering to the Sunshine Act. Unfortunately, right now, as being a citizen, the only avenue that you have in which to pursue sunshine violations is to file with Court of Common Pleas. And for that, you need to have an attorney and you need to have money to be pursuing their lack of adherence to the sunshine violations. Also, I would be requesting mandatory ethics training for any newly elected township supervisors or newly appointed solicitors. In dealing with my local township, they don't seem to have the knowledge of ethics and the Ethics Commission and what the Ethics Commission does, and basically how to conduct business ethically, if that makes sense. We are a very small community. And if you're familiar with Schuylkill County at all, unfortunately, it's a very poor area. People are uneducated, undereducated in my area. So the vast majority of the population, some of the things that they're doing incorrectly completely go over their heads. And I'm not trying to speak negatively about my population, but overall, there is a lack of interest in government from the local citizen perspective, especially local government. But unfortunately, as limited as local government powers are, they do have a lot of power over you as an individual in your personal property, your home, the property in which you own. My current situation is I had requested the local financial interest forms. As a Commonwealth employee for over 20 years, I have to do them yearly. And general counsel, who's in charge of our agency, follows up to ensure that they're finished timely and that I'm accurately reporting information on my financial interest form. So in engaging in my township, and I have a laundry list of issues that brought me even to the point of requesting the financial interest forms, it has been a very frustrating process. So I did a right to know request, even though I didn't have to for the financial interest forms. And Executive Director Fox has been in communication with me the entire time, which I greatly appreciate. I did a right to know request. The township requested an extension, and then the township also failed to provide any documents. I was able to figure out what to do next, which isn't common knowledge amongst, just the regular general population. So I followed up with Office of Open Records. I filed a complaint with Office of Open Records. They entered an appeal. Some time had gone by. The township never even participated in the appeal. Office of Open Records then left the record open for another 30 days to allow them to participate, just to ensure that they had received service of the process. At the end of that time frame, Office of Open Records, basically said turn over the financial interest forms within 30 days. Unfortunately, the township failed to do that. So my only recourse after that was to file a mandamus with Court of Common Pleas here in Schuylkill County. Now, it's a very, I'm doing it pro se because I'm not going to hire an attorney. It's very expensive. It's a time consuming, on my behalf to educate myself to be able to write this and file it. The filing fee alone was $127, and then I had to send it certified mail, which was another $11.60. The whole point of me bringing this to the attention of the Ethics Commission in this public meeting is me personally having gone through this extreme battle with my township. As a private citizen, I would definitely like to see more oversight into local government. I understand that, they're just responsible for their own financial filings, financial interest statements, ensuring that they're done properly and timely. But if they fail to do that, there's nobody watching over them. In my experience with the Commonwealth, local government is the most or least overseen area of government, if that makes sense. Even in reaching out to the General Assembly for the Commission on Local Government, the unfortunate answer I get is, it's basically up to the voters to oversee their elected officials. And I completely understand that. But when you have elected officials that have LLCs and owning rental property, but then they're the ones responsible for following through on their zoning ordinances and their code ordinances. And because they own rental property under an LLC, they just don't have the township follow up on their code of ordinances, ensuring that these rental properties have to be inspected yearly, if that makes sense. So on top of that, they have the responsibility of zoning in East Union. And they've handed down some questionable zoning decisions as recently as this week. And a lot of the turmoil within East Union is being documented by the Shenandoah Sentinel, which is a local news reporting agency. She is an independent reporter, and she does a really good job at capturing some of the issues that are occurring here. But I'm in the same boat as some of my other local municipalities. The Shenandoah Borough is struggling. Black Creek is also struggling. And just through my trials and tribulations, I've reached out to local municipalities just to see if they're encountering the same difficulties that I am, in which they are. So thank you for your time. My thing is I would like to see some more oversight, and I understand I was excited to hear that Director Fox had mentioned that there's legislation for a manager of local government, which I think is a fantastic idea, and I would love to see that through. Just for, low man on the totem pole here, sitting in East Union Township, just trying to live my life. It's become challenging just because of personal feelings with my local supervisors. If we personally disagree on something, it's almost felt as though they take it out on me and things that I'm trying to do with my property. Also, people that have supported me in my causes of questioning what they're doing in our local government. So not to waste any more of your time, but that is my rant.
Not wasting time at all. Thank you very much. I certainly would ask our executive director to follow up on the filings of the statement of financial interest.
Yes, sir. And I do believe that she has. Like I said, she has been really great at communicating with me. It's just, for me, being a Commonwealth employee, being responsible for my employees as a supervisor, I can't understand how it's state law, and I have to go through all of this process to ensure that they're following state law, if that makes sense.
I may just make a short response. Ms. Oster's correct from a procedural, as far as I know, from a procedural perspective, what she's saying is correct about what has happened. We're aware that there are times when townships, boroughs, other governmental entities either don't realize or don't provide statements of financial interest upon request. Unfortunately, we have no statutory enforcement over these local governmental entities in providing these forms. I think citizens then are required or forced to go through the right to know process, which can be difficult. But we don't have the statutory enforcement authority. What we can do is do compliance reviews, which we have done in this case, and which we will continue to do. And we will continue to pursue that. But there is an avenue for recourse by law, and it sounds like Ms. Ostra is exercising that.
Great. Well, thank you, Ms. Ostra. This is something we do want to be brought to the attention of our commission. I am certain that Ms. Fox is using whatever appropriate authority she has to further follow up. And you are correct, no matter the size of local government, there is obligations to file these statements of financial interest, and we do have a right to audit those and enforce non-compliance. So we appreciate your comments. Any other public comments? Well, thank you, everyone. I hear no further public comments. I won't call on one of our former folks in the room to see if he wants to say anything. Hearing nothing further, I'll entertain a motion to adjourn the public meeting.
So moved.
And a second. All in favor? Aye. Just before I adjourn, Ms. Fox, did I miss something? Oh, okay. Yeah, I didn't know whether that was actually out. So we did have on the public agenda a lobbying matter, Button Holdings, Inc. As I understand, that is going to be submitted to us for decision at our next meeting. Is that correct?
I'm hopeful to submit all of the materials are November 15th.
It'll make the agenda.
It would be on the January.
And that was by agreement of the parties to defer consideration from today to our next meeting. So just for those who saw something on the agenda and are wondering why we didn't get to it, thank you for raising that. That being said, I think we took a vote to adjourn, and we will take a 15-minute break before we go into our executive session. Thank you, everybody.